The blue is the petitioner, memo. Blue is the petitioner, memo.
upon the same by the state and non-state actors has to be prevented if a democracy is to be sustained. Now, in the present case, it is relevant to look at the agreement which was signed between the respondent company and the patients. Your lordships may refer to the Moot proposition. Para 10 of the Moot proposition, your lordships.
Yes, for video.
Do I have a lordship? The lordships, in the agreement which is signed between the respondent company and the patient, if I may read out the clause, it is mentioned that the patient shall agree to share the data and information biometric as well as personal information, not limited to not personal information, not limited to patient information, and personal health ID details with medical future. In the present case, the company, that is Medical Future, is requiring the biometric information as well as the personal information from the users. The losses biometric information has been classified as sensitive personal data in the IT rules 2011, also referred to as the sensitive personal data and information rules. The losses it also casts an obligation to on the respondent company to undertake heightened measures to protect this kind of data. And if you are refer to the
2010, how will come out of cross B? Same cross, 10B, last two lines, read cross B.
Indeed, your lordship, I would be reading clause B for you. Meditech Futura shall exercise due diligence in the safety of information and shall be exempt from any liability the information or its computer resources are unduly interfered with or for any circumstances which are beyond its reasonable care and supervision.
And then read paragraph 14, last three lines.
Indeed, your lordship.
The data was leaked.
Your lordship, the last four lines of para 14 states the data was leaked to an anonymous account handle called the Watcher, who claimed to expose the weak data protection regime of Elysium. Medical Future promptly informed users of the leak and assured that immediate steps to ensure the safety of their data would be taken by. Your lordship, my
Would it not then be exempted the read with this to clause?
Your lordship, I would be dealing with the second clause of the agreement to establish that the due diligence that is so promised in the second clause has not been complied with by the respondent company. But before this, your lordship, my concern before this honorable court is regarding the lack of informational privacy, which is present in the present case, and also that the company has not taken the informed consent of its users. Your lordship, if I may draw your attention to the compendium for the petitioners.
Yes, page.
Your lordship's plan 2. Your lordship's plan 2, page 19. Page 19, para number 201. Do I have the lordships with me?
Yes.
The lordships over here, the principles from the European Union GDPR have been cited and they have emphasized on the principles of data minimization and purpose limitation, which state that only the data which is necessary for the functioning of any facility can be collected by the intended providers of the information, as well as the provision of purpose limitation has been stated, your lordships, which means that the company body corporate has to specifically provide the purpose for which the information is being collected. Your lordship, this is foreign jurisprudence, but I would like to draw your attention to the Indian jurisprudence.
I think the Moot proposition is that you are for the Republic of Elysium are the judgments of Indian Supreme Court, binding on the Supreme Court of Elysium.
Your Lordships, I am counsel for the petitioners. I am representing Mr. Dragons and my.
You are before the Supreme Court of your country. That's the first way.
Indeed, Your Lordship.
You are going on repeating that the judgments of India Are they binding on us?
Indeed, Your Lordships, if you may refer to the Moot proposition on.
Forget Moot. This is a clear question. Because there are marks for it.
Indeed, Your Lordship.
There are marks for it. You are for Elysium. You are in the Constitution. Republic of Elysium.
Indeed, Your Lordships. Your Lordships, the laws of India are parallel to the laws of Elysium.
That's it.
Oh, right. That is what you have to
Correct.
answer.
Correct.
Now go ahead. Now
Correct.
Much obliged, Your Lordships.
Yes.
Your Lordships, as I was emphasizing on the principles of data minimization and purpose limitation in the European Union GDPR, I would like to draw your attention to the IT Rules 2011. And for that, if Your Lordships may refer to flag 16 of the compendium.
Paragraph.
Your Lordship, I would be referring to the relevant rule. And if Your Lordship may refer to Rule 4 of the IT Rules 2011, Your Lordship, Rule 4 clearly mentions that the body corporate has to specify the type of information that is to be collected and the purpose for the same. In the present case, the company has failed to provide the kind of information that it would be requiring from the users. They have specified that they would be collecting biometric information. Now, biometric information is an umbrella category. Everything that comes under biometric information constitutes sensitive personal data. And with regards to sensitive personal data, there is a need for explicit consent that needs to be taken. The company has inserted a non-restricting clause in clause A of its agreement and has stated that it can collect any information not limited to facial information and personal hair dyeing details, which means that it is now upon the discretion of the company to determine what kind of information is relevant for its purpose or objectives. This is blatantly against the cardinal principles of privacy, which have been stated in the case with the Swami judgment. And if I may draw your attention to flag 1. Flag 1 of the compendium, Your Lordships, page 8.
Page 8.
Indeed, Your Lordships, page 8, para 314. Your Lordships, there are certain cardinal principles of privacy which have been cited in the present case. These have been enunciated in the report by the expert group of experts committee which was constituted under the Planning Commission. Your Lordship, these principles clearly emphasize on the principles of collection limitation as well as purpose limitation. It is a need for the body corporate to clearly mention this kind of information that is to be collected before requiring such information.
Madam, would you turn to page 145, subgroup 4?
Your Lordships, the IT rules.
Yes, subgroup 4. It is not protected institution.
Your Lordships, subrule 4 of.
The third party.
Your Lordships, subrule 4 of which rule?
Yes.
So, Your Lordships, there is a humble request from the council if you may direct the council to the relevant rule.
You read disclosure of information.
Rule 6.
Rule 6, subrule 4, 145.
Page 145.
Indeed, Your Lordships. Your Lordships, Rule 6, subrule 4 states that the third party receiving the sensitive person data or information from body, corporate, or any person on its behalf under subrule 1 shall not disclose it any further.
Therefore, the person who is taken by fraud, that the information is kind of. Therefore, the person who has received, he will not circulate. And how we will come out of this rule?
Your Lordships,
That company will not, the doctor and the company will not be liable. They have not circulated. It's not your case.
Your Lordships.
They have circulated.
Your Lordships, I am in no way contending that the respondent company has circulated the information.
Disclosure is by fraud. That's a fact says. Paragraph 14. Anyway, we will proceed.
Your Lordships, just to clarify, my submission is that the company has not undertaken due diligence as is required of it under the law. Your Lordships, IT Act under Section 43A states as IT Act 43A read with Rule 8 of the Expedia rules on page 145 clearly casts an obligation upon a body corporate to take organizational as well as technical measures commensurate with the nature of information assets that are to be protected. In the present Rule 3 has clearly specified sensitive biometric information under sensitive data and information. Therefore, the responsibility to protect such information is not only to a basic level, it has to be elevated to a heightened level. The company has to undertake multiple levels of protection when it comes to safeguarding such information, Your Lordships.
Then the data was leaked by fraud. Data was leaked by fraud. Therefore, the query of the would be that if the data is leaked by fraud, the company would not be responsible. Fraud is there. So, company has not leaked it. But then your submission seems to be that company has not exercised due diligence to prevent fraud also. Is it your submission?
Your Lordships, because the software of the company, Dr. Precision, did not incorporate even the basic safety protocols, it became a petri dish for the hackers to come and access that data.
They had the permission of the government. Exactly, I'm not. If you read clause B closely, the company shall exercise due diligence. They have said in safety of the information shall exempt from any liability. That itself, if the due diligence is not there, they have themselves in that they have said shall be exempt from any liability in the event information of the computer resources are unduly interfered. Therefore, they have protected themselves in the clause B itself. Therefore, I pointed out clause B, read with clause 14. You are not coming out of that.
Your Lordship, the Council appreciates the concern. However, I would like to request your Lordship to have a look at para 18 of the Moot proposition, which states that the investigation by the Forum for Netizens' Rights has revealed that Meditech Futura lacked even the basic safety protocols and encryption norms.
No, then you are not reading two facts in paragraph 18. The third line. Possibility of the data from Medicare Future being leaked through share. The third, again, that sub agency of that another party. That line you are not reading in paragraph 18. Otherwise, you are right. Paragraph 18, first line, protect you. The third line will go against you.
The Lordship, the third line states its data being hosted on the same server as Chirp, hence highlighting the possibility of the data from Meditech Future being leaked through Chirp. Your Lordship, this can also mean that if any person has an account on Chirp, or if a person has accessed the server of Chirp, they might as well get access to the servers of Meditech Future and they extract such data from the server, Your Lordship.
Therefore, madam, if you read clause B, read with paragraph 14 and 18, the hospital or the company itself will not be, because the subcontractor of the other party has committed a fraud, not the company. They have taken all the diligence, but the party with whom they have entered in contact, somebody has played mischief.
Your Lordships, by the jurisprudence of contract law, if the
no criminal, there is no vicarious. Only civil liability, yes. Suit for damages, yes. But you have filed criminal complaint.
Your Lordships, we have indeed filed a criminal complaint because the gist of criminal offences is intention, which I will be stressing on in the second limb of the argument. But to answer your Lordship's query regarding the exemption clause, your Lordship, I am establishing that this agreement, which was signed between the respondent company and the patients, it is void. Now, if the agreement is void, the same cannot be enforced, and the company cannot enforce this exemption clause before this honorable court. Your Lordship, the agreement is void. Why? Because the agreement fails to honor Article 21, which clearly states that informational privacy is a facet of Article 21. Informational privacy is the right that an individual has over the dissemination of his or her information. In the present case, the users are not aware of the kind of information that is being asked from them. It is solely on the discretion of this body corporate.
You want the FIR to be lodged against everybody, probably against some particular people. What do you want?
Your Lordship, the FIR must be lodged against every person. In the present case of people who have violated the privacy.
How do you say 509 is it?
Your Lordship, 509 talks about the words, gestures, and insult intended to outrage the modesty of a woman. Your Lordship, in the present case, it has been stated that there were certain deepfakes which were uploaded on the social media platform Chirp. And it can be inferred from the same that your Lordship is being inferred.
There's nothing like inferring in 509. You read the judgments of this court. Okay, you go to your limb of argument.
Indeed, Your Lordship. To conclude the first leg of my argument, I would like to state that the agreement has not culminated into a contract for falling short of the conditions which are mentioned under Section 10 of the Elysium Contract Act. And also, Your Lordships, the agreement fails to uphold the principle of information privacy, which has been traced back to Article 21, and therefore the agreement is void, Your Lordships. Your Lordship, the second leg of my argument is that the conduct of Meditate Future establishes criminal liability. Your Lordship, as Your Lordship are directing me to the criminal charges which have been levied against the respondent company, there are three charges which are framed against Meditate Future. One, the first charge is under Section 405, which talks about criminal breach of trust. Your Lordship, the ingredients of criminal breach of trust are: first, there should be an entrustment of property. In the present case, the sensitive personal data and information of the patients was entrusted by the patients to the respondent company. And the second ingredient of the said offence is that the person to whom such information is entrusted must dishonestly misappropriate the same in violation of direction of law. Also, in the present case, the IT Cyber Technology Act 2019 in the Republic of Elysium clearly mentioned under Section 43A, read with Rule 8 of the SPDI rules, that the body corporate must account for the entrusted data. In the present case, Meditate Future has failed to do the same, because of which the charges of criminal breach of trust are prima facie established. You also further.
43A only provides compensation.
Your Lordship, 43A also casts an obligation upon the body corporate to maintain security and reasonable care with regards to protecting the data of the users.
You have IPC? IPC?
Indeed, Your Lordships.
Read 406. Take it.
Your Lordship, may I?
Take it 5 copy. 406.
Your Lordship, 406.
I have given you.
Your Lordship, section.
Definition of criminal breach of trust. File complaint 406.
Your Lordship, 406 or 405.
406.
Your Lordship, section 406 states the punishment for criminal breach of trust.
And definition of that. What is criminal breach of trust?
Indeed, Your Lordship. Whoever, being in any manner entrusted with property or with any dominion over property, dishonestly misappropriates or converts to his own use that property.
Own use. How it will come? The company has not used, assuming we accept your argument, company has not used for his own benefit.
Your Lordships?
By disclosing this fact, company is not going to be benefited in any way.
Your Lordship, as per my understanding of section 405, either of the conditions has to be fulfilled. Either there has to be a dishonest misappropriation, or there has to be a conversion to one's own use, or there has to be a use or disposal in violation of the direction of law which prescribes the mode in which such trust is to be discharged. Your Lordship, in the present case, the Cyber Technology Act is extremely unambiguous in specifying the way the body corporate has to deal with the sensitive personal information. And on account, if your Lordship may also refer to the compendium for the petitioners, your Lordship, tag 6.
Yes.
Your Lordship,
Page 52.
page 52, para 6.
6, last 3 lines.
Your Lordship, it has been mentioned that when it comes to inferring intention with regards to the offense of criminal breach of trust, a failure to account for the property entrusted can very well can also make the intention to be drawn out from the offense. Your Lordship, since in the present case the company has not accounted for the data that was entrusted with it, there is an inference which can be.
I think you will not disturb you, otherwise paragraph 7, the defense which was taken in that text is that the quotes are written by the aunt, that if you read it was Odin was written by the white ants and moms. That was the defense. Therefore, what I believe that this was a defense which was absolutely bogus. You are reading paragraph 6, but on text, paragraph 7 of that text.
Your Lordships, it is the submission of the council that the gist of the offence, that is, intention, has been made out against this warrant company because they have failed to account for the data.
All right. Good.
Your Lordships,
You are doing good, don't worry. You are responding to the court very absolutely. You are doing well.
Further,
Marks उसी के हैं. Marks उसी के हैं.
How you withstand the judge's query? And with the
सही
smiling
गलत
face,
आप नहीं देख रहे.
with the smiling face, you are doing it.
हाँ.
Keep it up. Your performance.
much obliged, Your Lordships. Your Lordships,
And definitely all the five may differ, huh? Don't worry.
Your Lordships, the government shall make its best effort in presenting its case.
Yes.
Your Lordships, further section 415, that is of cheating. The essential ingredients of cheating are, first, is that there should be a deception. First, deception is presenting something false as true. In the present case, the company has mentioned in its privacy policy that it would be exercising due diligence with regards to the data of the users which is to be entrusted. However, in the present case, the basic safety protocols have not been ensured by the respondent company in safeguarding such data erosions. It was under this deception that due diligence would be maintained that the patients decided to entrust their data. Had they known that even the basic safety protocols were not in place, they would have definitely not consented to giving their data. Therefore, this constitutes as
Then you
inducement.
will not get a good treatment. Therefore, I don't think anybody will not give. For best treatment, you have to give.
Privacy is an inseparable part of human life.
If you download any app, they also receive all permissions. Unless
Your
you
data is going there. Google, every data is going to Google. You don't know if you go to any restaurant 5 times, next time Google will say you will go and will sit in this chair.
Your Lordships,
we ordered this last.
Your Lordships, the concern that the Lordships are raising with regards to data being collected, the same concern has also been cited, has also been raised in the judgment of K.S. Swami. If you may refer to flag 1, page 4.
Madam, except Gupta Swami, any other judgment you want to refer? Because you have 20 minutes, you only use the name of Gupta Swami. It seems that you are over enamored by that judgment. Any other judgment you want to refer? The time is coming to an end.
Yes, sir.
There are marks for uses of authority.
Page 97. Page 97, you will be happy. Page 97 judgment is good.
No. If that, then what normally on this, by I look to, then your lordship of the dais,
97.
one minute, that is what I am requesting your lordship. That is what I am requesting this young, when we were really on dais, his lordship would take the lawyer. If it was a division bench or a full bench, and one copy is given, you would immediately say, "Hey, manners, give copies to each brother." You have given only 2 memorials, not memorials. The compilation is only for the first 2 judges. So I don't know what is there in 97.
Oh, second is not.
उसके marks नहीं है. How you cite? No. How she cites? उसके marks.
Yeah. Your
Not
turn.
compilation.
Your Lordship,
Compilation may be prepared by your professors also.
Your
Have you
Lordship,
present them? Have you
You have to
present
buy
them?
copy. That's a.
Have you present them is more
And
important.
you were knowing that 5 judges.
There is another question. Moot
Your
also,
Lordship, I seek permission to pass.
No, that is not the issue. We can read it, but it is for you to mention those judgments. In your moot court preparations, Kuttu Swami, this Swami, that Swami, also arbitrate. One Swami. No, on the lecture second. If I stop your time, this time will not be counted. Don't worry. Thank you. Go ahead.
Your Lordship, the council has cited the judgment of K. Putraswamy 2017 to establish privacy as a cardinal principle. Further, Your Lordship, I have gone further to cite the judgment of K. Putraswamy 2019, which is also referred as an Aadhaar judgment, in which the principles of data minimization and purpose limitation were
That
enacted.
goes against you. The Supreme Court of India said everything can be given. It should be given.
Council, you have.
Yes.
there is one question.
Indeed, Your Lordship.
In court also, a lot of data is taken by the court.
Indeed, Your Lordship.
And somebody may be involved in a criminal case. He is convicted by the transport. And then now he says why you have opted my judgment on this.
Indeed, Your Lordship.
You have taken any permission from your.
Your Lordship, the concern that Your Lordships are raising with regards to this.
You also say right
Right to privacy.
Why you have.
My lord is talking about the judgment where you the convict is been everything is observed against him and the complete judgment is uploaded on the website. It is available to anyone.
Indeed, Your
And
Lordship.
ultimately, if he is acquitted, will it not amount to breach of privacy?
Indeed, Your Lordship.
Then his acquittal judgment may not have been uploaded.
Your Lordship, I seek an extension to.
Yes, yes.
Answer it.
Your Lordship, this concern was also.
In rejoinder, you can respond.
Take over and respond.
Your Lordship, in the case of.
Whatever you think over, it will be better. Respond to
over
some.
and then respond.
Then
Respond in your rejoinder.
Take over.
That would be better. Have a discussion with your colleagues.
yes, thank you.
Thank you.
Your Lordship, I would like to answer the question right away.
Okay.
Your Lordship, in the case of Vyasa KG versus the state of Kerala, there was this issue which was raised by the complainant that the judgment of her conviction was uploaded on Google, when in fact she had been given a bail. Your Lordship, the case was dealt by the court under the freedom of speech and expression to state that it is an order which is being uploaded on the court to inform the.
The name of the person. He has a right to find his.
Your Lordships, there are certain.
But there is no problem. Item of the case, name in the judgment body.
Your Lordships, apology, Your Lordships, there are certain measures which are definitely undertaken to ensure the privacy of the individual. For example, sometimes in certain cases, in particular POXO cases or sexual assault cases, there are instances where the petitioners are referred to by the by X or any other.
Let the next one.
Your Lordships, I would also like to argue the second issue to this on the report.
Your time is up.
Your
It
Lordship,
will run contrary counter to you. It will take away your colleague's time.
Your Lordship, in
You
the
seek permission from the bench.
Your Lordship, in the interest of justice, I would seek an extension to deal with the second issue.
Second man should get a chance.
If you recollect what I told yesterday in the inaugural, I told you, it will take away your friend's time.
Anyway, now.
Don't worry, we have not decided the case.
Your Lordships, the second issue was pertaining to the social media intermediary chirp, but the council will be presenting the same in the rebuttal if.
Okay. Yes.
Your Lordships, my co-counsel would be dealing with the third issue, and it was indeed an honor arguing with compliment.
Yes.
Waiting to be honorable kind. Your Lordship, the council will be representing petition number 2 in the present case, which is forum for netizen rights, and would be dealing with the third issue before the honorable court, that whether the central drug authority has duly exercised its discretion while
Even the questions which we ask and the answers which they give are considered to be the time taken by the normally it's other way.
No.
Kitna वक्त के time बनते हैं.
No.
Lordship, the council will be dealing with the third issue before the honorable court, that is whether the central drug authority has duly exercised its discretion while granting approval to doctor precision. Your Lordships, before proceeding with the submissions, the council just wants to reiterate before the honorable court that the issue in this particular case before the honorable court is of the violation of right to privacy of the Nirvana community. And your Lordships, by right to privacy by its very nature is an inseparable part of the human life. And if it is separated from the human life, the human element in life would be impossible. And therefore, it was an obligation on the part of the state to protect the fundamental right to privacy of the Nirvana community. If your Lordship don't have any preliminary questions, the council would like to proceed with your submissions. Your Lordship, my submissions are divided into two limbs. The first limb of my argument is that the central drug authority has failed to consider the privacy implications associated with doctor precision. Your Lordship, it is humbly submitted for the honorable court that the CDA has abused its discretion by granting an approval to doctor precision. Your Lordships, the central drug authority being an administrative authority had an obligation to consider all the relevant considerations before making a decision or before granting an approval to any medical device, any pharmaceutical or the drugs. And in the present case, since doctor precision is a medical device, an AI-based medical device, the relevant considerations associated with it would have been its data collection practices, its data security practices, its privacy norms, its ethical considerations, susceptibility to potential risk, etc.
Who was to check the data security part? Controlling authority.
Indeed, Your Lordship, the council would like to draw the attention of the honorable court towards page number towards page 247 of Your Lordship, apologies, Your Lordship, towards page 251 of the compendium for petitioners. Your Lordship, here by notification released in 2020 by the central by the CDSCO, which is akin to the central authority with respect to India, it has widened its jurisdiction and has clearly stated that it would now also examine the software as medical devices as well, and has also on the next page laid down some criteria which it would follow.
This is a new item.
No, paragraph 15, you get.
Your Lordship's read that.
Reaction by you people.
Your Lordship's para 15 states that, however, besides the leak of the personal details, the same CHUP account also uploaded certain details of the members of the Nirvana tribe, speaking in Elysium's widely spoken official language and making disparaging remarks against the members of the communities. The videos being deepfakes was soon identified by several fact-checker platforms. However, given the very nature of deepfakes, they generated hate and backlash against the members of the Nirvana community across the nation, furthering stereotypes against the community, thus aggravating the situation. And several cases of violence against the members of the Nirvana community were also reported across the nation. Lordship, that's the particular thing the council would like to highlight, that the central.
But that fact you read in paragraph 12, third line, and paragraph 13, last two lines.
Indeed, Your Lordship.
Believed to be suffering from a rare genetic condition that infected people of his community. And subsequently is again, paragraph 13, last two lines, began to use for other suspected patients as well, particularly the number of change type. And then your paragraph 15.
Indeed, Your Lordship, the council states that the petitioners don't have any problem with the device. They have the problem with its privacy policies. And Your Lordship, the central authority,
But that act was overall defecting your whole community. That you have facts. See, every fact you have to read between the word. Therefore, I have given you the word. Believe to be suffering from the rare genetic condition that impacted people of that community. Those community is likely to impacted, and he found again in paragraph 13.
Indeed, Your Lordship, the community was suffering from rare genetic diseases. That's why it required a diagnosis of that particular disease. And the central authority was under the obligation to provide a medical device or provide an approval to a medical device. But by doing so, the central authority was also under the obligation to consider all the relevant considerations associated with it and make sure that the device in no way harms the privacy or any of the rights of the individuals. And Your Lordships, to further emphasize on that, the council would like to draw the attention of the honorable court towards page 212 and 213 of the compendium. Lordship, page 212 and 213.
Yes.
The Lordships are on the same page. The Lordships, here, these are the guidelines issued by the ICMR for the central authority, with the central authority to follow while granting approval to an AI-based surveillance. The Lordship, point 10 of the guideline clearly states that highest security standards must be adhered with regard to patient data. The Lordship, in the present case, forget about the highest security standards. It has been clearly found and has also been established by the incident which has occurred that even the basic security protocols were applied. Your Lordship, the council wants to state that the central authority had an obligation to consider all the relevant considerations associated with it. They have failed to do it. Your Lordship, council wants to say that central authority is an administrative authority and the court should hold them accountable and direct the central authority to pay adequate compensation and also to investigate on the particular matter. Furthermore, Your Lordship, in the same guidelines, the council would like to draw the attention of the honorable court towards point 14. The Lordship, point 14 clearly states that there is an obligation to ensure that there are additional security measures in place to protect the rights and securities of a vulnerable group of the society. Your Lordship, in the present case, since Nirvana community is affected by a life-threatening disease and is on the verge of extinction, and furthermore is also a tribal group, thereby it is a vulnerable group of the society. And by virtue of being a vulnerable group of the society, following the doctrine of parents patria, the central authority, being the state, had an obligation to protect the rights of this vulnerable group of the society and to ensure that no particular right of this particular community is being violated when they are exercising their discretion or when they are granting approval to a medical device. Moving further, the council would like to proceed with the second aim of the argument. Lordship, second aim of my argument is that the central authority has failed to consider the AI implications associated with the document. Your Lordship, it is humbly submitted before the Honorable Court that the very nature of the AI is that it consumes vast amount of data in its training and operation. Your Lordship, since in the particular case AI is incorporated in a medical device, so the data which it would collect would be the social security numbers, the contact information, the previous medical records, biometrics, and all, which are all in the nature of sensitive personal data. And Your Lordship, if these data are not protected, what can happen? So what can be the consequence? For that, the council would like to cite the example of AIMS data leak, which is also mentioned on page 229 of the compendium. Lordship, in 2022, AIMS experienced a cyber attack caused by unauthorized access to AIMS network due to improper network segmentation. And in Lordship, how this data can be further misused. The council would like to draw another example of RAID-RP database in which records of more than 30 million users were disturbed.
This is one. Anybody want to respond to that? or this was a data leak, or somebody has hacked it. And you know that is responsible in the authority who are bound to audit all this.
Indeed, Your Lordship, in the rail Yatri case, the rail Yatri was penalized for the weak data security practices and for this particular incident. Moving further, Your Lordship, it was also an obligation on the part of the central authority to consider the due inaccuracies that might creep in due to the functioning of the AI. Your Lordship, as clearly mentioned in para 6 of the Moot problem, Your Lordship,
Yes, yes, paragraph 6.
Your Lordship, in para 6, it has been stated that doctor precision's functioning was premised on the comparison of patient's facial feature to the pre-existing database. Your Lordship, in the present case, it has been mentioned that there were certain existing stereotypes against the Rivana community. And if Dr. Precision is working on based on pre-existing database, it creates a possibility that there might be a situation in which those stereotypes may accentuate. And this particular consideration was also ignored by the central authority by granting an approval to Dr. Precision.
Have you pointed out any security since your submission that they have not taken protect rights of security or particular what you have additional security measure?
Indeed, Your Lordship.
What is your suggestion? What they should have taken additional security measure and which they have not taken?
Indeed, Your Lordship, the additional security measures would have been layer by layer encryptions, or the company should have incorporated more firewalling, more network segmentation, as already been mentioned by my co-counsel.
They were not expert. They were entrusted to the third party. Hospital was not the expert. Today, even in Jewish University, we are only teaching. The data is to be handed over to somebody else. Somebody else is managing. In that case, then what? Since you have said this word in your submission, additional security. What additional security ought to have been taken, they have not taken.
Indeed, Your Lordship, the council wants to submit that it was an obligation on the part of the central authority to ensure that whether there were adequate security measures or not. Your Lordship, as mentioned in para 14 of the ICMR guidelines, para 14 of the ICMR guidelines, yes, indeed, Your Lordship. Indeed, Your Lordship. When there is a case of a vulnerable group, their data should be, apart from the basic security norms, there should be additional or more efficient security norms to protect the data of a vulnerable group of the society, which the central authority has created. To conclude, Your Lordships, therefore, the central authority, by granting an approval to Dr. Precision without considering the due AI implications and privacy implications associated with it, has abused its administrative discretion and should be held liable for it. If Your Lordships don't have any further questions, the council would like to proceed to the prayer. Therefore, in the light of the issues raised, authorities cited and arguments advanced, it is most humbly submitted that the Honorable High Court of Elysium be pleased to first dismiss the petition seeking caution of FIR, and second, direct the central authority along with Meditech Future and Chubb to pay adequate compensation to the users and the members of the Humana community, and or pass any other order, direction, or relief as this Honorable Court may deem fit in light of justice secretary good conscience. And for this act of the Honorable Court, the petitioner shall forever be duty. All of which is most respectfully submitted. It was a pleasure arguing for the Honorable Court.
The council seeks permission to close ties.
Yes.
Much obliged. Council also seeks permission to the bench to produce relevant documents where and when necessary. May I address this collectively as Your Lordships? Much obliged, Your Lordships.
Come to the point.
Yes, Your Lordships. Your Lordships, the council, the respondents in the case of Mr. Baggins and others versus Metric Futura represented by Alon Hunt and a number. Your Lordship, there are three main issues in this regard. Your Lordship, I'd also like the court to consider our oral submissions to not be precluded by written submissions. Your Lordship, there are three main issues in this regard, which are put forth in page number 8 of our written submissions. Your Lordship, yes, Your Lordship.
My lord, the whatever response.
For the respondents, Your Lordship. Your Lordship, the first issue that is regarded in this case is whether there is a prima facie case against the first respondent and whether the FIR filed by the petitioner, Mr. Baggins, can be quashed. Your Lordship, whether the privacy of the first petitioner and other suspected patients have been infringed because of the first respondent and consent obtained by the first respondent from Mr. Baggins and other suspected patients was pre-informed and reasonable consent. That is the second issue, Your Lordship. And the third issue is whether the second respondent, that is the Central Drug Authority, has hastily approved the artificial intelligence software without ensuring adequate safeguards. Your Lordship, I'll be dealing with the first and third issue, and my co-counsel will be dealing with the second issue. Your Lordship, if I may move to my arguments. Your Lordship, I also be directly referring to the petitioner's submissions, and I'll be going against him. Your Lordship, first, there is no prima facie case against Chubb or MedTech Fixer. Your Lordship, my first limb of my submissions are that Chubb is a significant social media intermediary. This has already been established within the clarifications that have been provided along with them. With the proposition, Your Lordship. Your Lordship, Chubb is a significant social media intermediary, has the provision of safe harbor that is available for it under Section 79 of the Cyber Technology Act. Your Lordship, Section 79 of the Cyber Technology Act itself is a liability exempting provision and not a liability imposing provision. Your Lordship, Section 79 begins with notwithstanding any other law enforced, meaning that the intermediary will not be liable for any offence or any civil liability under any law enforced as long as it complies with the compliances provided under Section 79. Your Lordship, Section 79, subsection 2 and subsection 3 are providing for the compliances. Your Lordship, the first compliance is that the intermediary must not initiate, select the receiver, or modify information contained in the transmission. There is no particular submission in that regard, and none of this has been done by Chubb, Your Lordship. In regards to Section 79, subsection 2, clause C, Chubb has to observe two things, Your Lordship. Number one is due diligence, and number two is comply with other guidelines passed by the central government. Your Lordship, in the first place, due diligence has already been complied with. Your Lordship, it has been provided as the clarifications that Chubb has complied with encryption norms, it has taken encryption norms, it has taken endpoint security measures, and internal content control. Your Lordship, due diligence is not only listed under this part of Section 79, it is also listed under Rule 3, Subrule 1, Clause B of the Cyber Technology Rules. Your Lordship, Rule 3 as well as Rule 4 provide for due diligence compliances of a significant social media activity. And Rule 3, Subrule 1,
if they were good and how did we got this?
Yes, Your Lordship. Your Lordship, besides their due diligence, the data has been leaked because of the hacking committed by a third party called the Watcher. Your Lordship, the Watcher on the social media account has.
What did you do against them? Did you take it away?
Yes, Your Lordship. Your Lordship. Yes, Your Lordship. Your Lordship, Your Lordship, the government had passed an order under
What's that? Is there a delay in this promotion?
Your Lordship.
This taps here.
Yes, Your Lordship. Your Lordship, in page number 11 of the memorial, we provided that Chubb has complied with encryption norms endpoint in paragraph 3, Your Lordship.
Paragraph 3 of
the memorial, Your Lordship.
No, what my question is this. There is an admitted position of fact that the data has been leaked. You say there's been hacked and not leaked, right? Against the hacker, what have you done?
Yes, Your Lordship. Chubb has blocked access and has removed
Can we get it in record?
Yes, Your Lordship.
Normally the removal of content.
Yes, Your Lordship. Your Lordship, under 69 Chapter A of the Cyber Technology Act, the government of Elysium had passed an immediate order for removal, following which Chubb has complied with it, Your Lordship. Under Section 79, Clause 3, Section 79, subsection 3, Clause B, It has been listed that if an intermediary complies with a government order, and your lordship, that has been clarified in the case of Shreya Singhal versus Union of India also, that actual knowledge would either refer to a court order or by an order of the government. Your lordship, since the government has issued an order and there was immediate removal of this content, SLF has complied with all due diligences and has to be protected under the safe harbor provision under section 79. Your lordship, if I've satisfied the rents,
There is a law required that you have to keep the data in the same country or you will keep it abroad.
Your lordship, there is no specific law that provides that you cannot store the data abroad, your lordship. There is no specific law in that regard, your lordship. Assumptions have not been
All the
made.
security features should be examined by the country. Which the data belongs.
Yes, your
The
lordship.
data is maintained in our country.
Yes, your lordship. Your lordship, the petitioner had made submissions in that regard that the principles of GDPR should be interpreted by the court. Your lordship, in that regard, GDPR only regulates data that is there in the EU. Your lordship, it only regulates data that is of the citizens of the European Union and not of Elysium. Your lordship, the data that's stored even in the cloud infrastructure in Netherlands is protected by the rules that are provided by the government of Elysium and not by the European Union. Your lordship, and may I move to the next limb of my Your lordship, the second limb of my argument is that the offence set out against Medtech Futura specifically, the offences set out against Medtech Futura is not met. Your lordship, what is being alleged in this case is a criminal offence. Your lordship, this is a criminal offence against corporate bodies. Both SHERP as well as Medtech Futura are corporate bodies, are body corporates. Your lordship, if in regards to attaching criminal liability to body corporate, it has to always be vicarious. Someone should be held responsible for that.
For compensation, they will be held responsible.
Yes, your lordship. But in regards to that, your lordship, my co-counsel will be making assumptions how compensation should also not be given in this
That
case.
is on merit. If you say the corporate body can't be there,
Yes, your lordship.
the Act only provides that for compensation.
Yes, your lordship. Your lordship, but the IPC does not make a clear. Your lordship, there has to be a specific provision in regard in order to attach vicarious.
Corporate body can't be there, but compensation there.
Your lordship, the allegations that are made out are under the IPC, Indian Penal Code, your lordship. The provisions that have been provided are for imprisonment, your lordship, and that is what the petitioner is specifically seeking for. Your lordship, if you look at section 499, 509, section 153 capital B, 153 capital A, 405, 420, your lordship, all of these offences that supposedly Alone Husk is liable for would make us.
One.
Yes, sir.
Now that the laws of India are very material cards, if you read section 357, the procedure is not what ITC says. Procedure is what CRTC says. Therefore, my brother's question was very pertinent to you. What about compensation?
Yes, sir.
Say you want to wriggle out of this criminal, all this hacking business. Are you ready to pay compensation? That is the basic idea.
Yes, sir.
Would you feel like giving a quiet earth to this litigation by offering compensation to the victims, the aboriginals of my country, and put a quiet earth to this? That's a simple question.
Your lordship, without any negligence on part of Medtech Visa or SHERP, the Medtech Visa.
If you want to litigate, that is what we understand.
Yes, sir.
Okay.
Yes, sir.
Fine.
You see, you are seeking for,
Yes, sir.
it's not matter of investigation.
Yes,
Whether
sir.
you have taken due diligence, whether security features are there or not there. How it can be examined at this stage? Is the FIR?
Yes, Your Lordship. Your Lordship, in the nascent stage, an FIR can be quashed if prima facie offences are not made out. This
How
means,
reach is there?
Your Lordship, prima facie no clear dishonest intention has been made out on
That is
part.
all matter of investigation.
Your Lordship, some amount of it, Your Lordship, in actual regard, in regards to the proposition itself, it has been stated that Elon Musk has actually made certain statements, Your Lordship, that are stating that he wants to improve the healthcare within.
That's all right, you
the
mentioned very good. They say it's an intention breach, you have leaked the data. Your case is it's a hacking.
Yes,
Somebody has to examine it. Any technical issue.
Yes,
An expert body will examine the whole report.
yes,
If it is a data breach, so you have leaked it, then you are responsible. If hacking is there, maybe a different issue.
yes, sir.
But how it can be caught at this stage?
Yes, Your Lordship. Your Lordship, in fact, MedTech Future is also an affected party, Your Lordship, and their application is
No,
also
not
not.
that.
Your Lordship, section 43, small a, read with section 66 of the Cyber Technology Act, actually provides that hacking itself is an offense, Your Lordship. Your Lordship, the FIR has been filed by the petitioners within 2 days, Your Lordship, post the data breach. And the FIR has been filed against MedTech Futura as well as the hacker. Your Lordship, MedTech Futura, if it had the opportunity, would have filed an FIR against the hacker himself, Your Lordship, which had accessed our computer resource that was situated in the cloud infrastructure, and he had unauthorized access to the computer resource by hacking. And that is what has led to the data breach. And MedTech Futura or CHUP, having taken all reasonable compliances, cannot be held liable. If they are held liable, then it would be against the reasonableness that is inherent under Article 14. Your Lordship, if I may make submissions in regards to issue 3. Yes, Your Lordship. Your Lordship, issue 3 is whether the Central Drug Authority has taken appropriate safeguards in approving the artificial intelligence software, Dr. President. Your Lordship,
How can you answer this question?
Yes, Lordship.
You are being for those numbers.
No, Your Lordship, I'm also appearing for Central Drug Authority. Yes, Your Lordship. Your Lordship, the Central Drug Authority has taken appropriate safeguards in approving the
Then all of you should be convicted. You are appointing the same council.
And the accused say no.
Lordship, because of the issues we've
No, don't get caught up.
Yes, Your Lordship. Your Lordship, the petitioners have not even referred to the actual law, Your Lordship. The submissions were not made in law. They were completely based on the ICMR guidelines, which are not binding on the Central Drug Authority, Your Lordship. What is binding on the Central Drug Authority, which is a statutory body established under the Drugs and Cosmetics Act, is the medical devices rules in the present case, Your Lordship. Your Lordship, as per the notification, if Your Lordship prefer, I'd be giving the notifications. Your Lordship, as per the notifications, notification SO 648E released by Ministry of Health and Family Welfare, a software that is to be used for the specific purpose of diagnosis is also a medical device under Section 3, subsection B, clause 4 of the Drugs and Cosmetics Act. So it has been notified that software that has been
Under which provision those ICMR guidelines have been issued?
Your Lordship, they have not been issued under specific provisions because they're merely guidelines passed by the Indian Council of Medical Research. The medical.
This is strictly what?
Your Lordship, as far as
right.
Your Lordship,
On duties.
yes, Your Lordship. Your Lordship, as far
Let
as
us see that under which is not.
Your Lordship, as far as I'm aware, the Indian
Council
Council.
expert body created for some purpose.
Your Lordship, as far as I'm aware, the Indian Council of Medical Research is an independent body, Your Lordship. Your Lordship, its guidelines are not binding because they're not specifically law, Your Lordship.
Okay, that's why under which act these bodies have been used.
Your Lordship, I am not sure about that. Your Lordship, if I may just talk about how the CDA grants approval in cases of certain devices. Your Lordship, in regards to Rule 8 of the memorial, in regards to paragraph 8 of the memorial, it has been provided that given its potential and the absence of any sustainable diagnosis mechanism for rare diseases, the tool received approval of the Central Drug Authority of NFSU. Your Lordship, that means there has been no other device for before the Dr. President in order to diagnose these rare diseases. Your Lordship, in the medical devices rules, Your Lordship, if you may want a copy of the medical devices rules. Your Lordship, under Rule 3, Clause X, subclause I of the Medical Devices Rules 2017, it has been provided that Investigational medical devices are those that have no predicate medical devices. There are also predicate medical devices are also been defined under the medical devices rules, which are predicate medical devices are the first of its kind that is comparable, that has some comparison and has already been granted approval. Here there is no predicate device, so therefore the AI software, Dr. Precision, is an investigational medical device. So the procedures followed by the central drug authority are in that regard. Your Lordship, the procedure that is followed for an investigational medical device is provided under Chapter 7 of the rules. Your Lordship, there has to be a clinical investigation taken, post which approval will be granted by the central drug authority. Your Lordship, the clinical investigation has happened in 5 months.
This authority cannot have any power to grant the approval. There is no something like AI. You must predict what is there in every case. It will predict.
Your Lordship, even if it is artificial intelligence, it is still a branch of software, Your Lordship. It is still coming under
How
software.
the central drug authority will grant information?
Yes, Your Lordship. Yes.
Those are all generated.
Yes.
You have also mentioned in your consent you have taken that you can use this data for further research and all that.
No, Your Lordship.
You also mentioned where do you think mentions in there? Just see.
Your Lordship, it
Other
is.
than
Yes, Your Lordship.
probably
Your Lordship, if I may read the clause A again.
clause A. Correct.
Yes, Your Honor.
Right.
Your Lordship, clause A states that the patient shall agree to share the data and information generated here, including biometric as well as personal information, not limited to facial information and personal health ID details, with medtech data, which can be used for enhancing the efficacy of the software.
Other also you are using it so tomorrow you may have a different result and a lot of data being processed in the end.
Your Lordship, that is
How this central authority could then grant permission? Nothing static. It's not a machine like blood pressure or measuring. It will uniformly clear the same system will be called for. This is generated.
yes, Your Lordship. Your Lordship,
So how they could grant? Tomorrow it may provide different kind of treatment to the same thing.
yes, Your
Or lot of data in process.
Lordship, it is merely for the purpose of the efficiency of the software that this is.
Right, so how they could foresee more over the
Yes, Your Lordship.
this device will AI tool will be.
Your Lordship, actually, AI softwares have already been given.
How they could have given the permission? You do not know tomorrow what this AI tool will be.
Your Lordship, the
Therefore, don't accept for the authority and accusation.
yes, Your Lordship.
Because you have been paid by the accused and you have to defend the
Authority also.
One more aspect. Your memorial itself,
Yes, Your Lordship.
there's a generation by you. 729.
Yes, sir.
Then why is my senior brother waiting for the right to report the FIR?
Your Lordship, it is.
You are accepting that there is breach. If it is, there is secondary liability. As my brother has rightly pointed out to you, if there is a prima facie liability, why should there be a caution?
Yes, sir.
And the judgment of 482 is very clear. It stays on your face. And the recent judgment taken by my brother stays on your face. The recent judgment taken by my other two brothers stays on your face. How do you get out of all those authorities?
Yes.
Therefore, we put it very candidly to you for your clients. Would you push away with compensation? You said, no, sir, I definitely waste your time.
And mine.
Yes, go ahead.
Yes, Your
How do
Lordship.
you get out of this?
Your Lordship.
29. Your own proposition you have kept it.
Your Lordship, out of the
See, the cardinal principle of criminal jurisprudence is you yourself are accepting completely liable. You get exonerated. Raise the music. Let the investigation go on.
judgment which you are getting.
which
Judgments, which judgment you are relying on.
Your Lordship.
Seeking quality.
Yes,
There are paid marks for that.
yes, Your Lordship. Your Lordship, in state of Haryana and others versus Bhajanlal and others.
That is based on your case.
What are the nine principles?
Yes, Your Lordship, if there's a prima facie case.
No, on a plain reading of a complaint, no offense is made out, then only what is power to.
Yes, Your Lordship. Your Lordship,
But
the
then
FIR
that goes against you.
Your Lordship, but the FIR has not even been made out against Alone Husk, Your Lordship. The FIR is not even against Alone Husk, Your Lordship. It is only against Medtech Future and Sir. They have not made out anything against Alone Husk. That Alone Husk is responsible. Who is responsible for this situation? Your Lordship?
Therefore, investigate.
Your Lordship,
Because
but
in
with
the
the
recent state, why FIR should be closed? Let investigating agency investigate and find out.
Your Lordship, but without
Even
even
the brother said rightly repeating, all five of them were different, they were.
yes, Your Lordship, I completely understand.
And do you violate any law by drafting this law? Because one of their argument is that you had taken a very blanket permission of biometrics, which is defined in the rules, all complete cutoff,
Yes, Your Lordship.
which you could not take.
Your Lordship,
I judgment on this.
yes, Your Lordship. Your Lordship,
Did you violate that?
not exactly, not at all, Your Lordship. Your
That is
Lordship,
also matter of investigation.
Your Lordship, under the, Your Lordship, contract law protects the,
Contract law, if it is in violation of law, any contract that is valid.
yes, Your Lordship. Your Lordship, under Article 21, it is being provided that there may be reasonable restrictions imposed on personal liberty as per procedure established by law. Your Lordship, right to privacy is inherent under personal liberty and reasonable restrictions can be imposed. Your Lordship, although this may sound ludicrous, I'd say that criminal law is also one restriction placed on privacy, Your Lordship, as well as contract law. Your Lordship, if you provide your privacy, your data to someone, Your Lordship, obviously
Under
under
consent, that it can be used for this.
Your Lordship, this is in the form.
Law to that extent.
Yes, sir. Your Lordship, this is in the form of a standard form contract, Your Lordship.
Standard has to be as per law.
Yes, Your Lordship. Completely admitted, Your Lordship. Your Lordship, even reading Article 14 and Article 19 together, as Article 21, 14 and 19 should always be read together because of the golden triangle principle. Your Lordship, it can still be stated that there is some reasonableness in the contract, Your Lordship, because Medtech Future states that it will take due diligence and take reasonable care and protection, and only when, if it is unduly interfered by a third party, it is not liable. Your Lordship, so this standard is,
That unduly is to be investigated. That is unduly or not.
Your Lordship, it is a clear case of hacking, Your Lordship. Therefore, it is,
That is your case. Their case is not that it is.
Your Lordship,
They say no permission, no proper audit by you, because you are appealing for authority also no lack of it.
There is conspiracy, now their case is more strong.
yes, Your Lordship.
And then one more aspect, you have never met the clear submission or violation of consent also. All that you have gone is IPC.
Your Lordship, in
You
regards,
mean to say your colleague is going to deal with drugs act?
no, Your Lordship, Drugs Act is in particular to the Central Drugs Authority, Your Lordship, and they have not even referred to the Drugs Act.
They have,
Your
they
Lordship,
have said.
yes, Your Lordship.
The question itself is framed whether the approval given by you was in contravention. That is what my senior brother has been asking you.
Yes, Your Lordship. Your Lordship, under Rule 63 of the Medical Devices Rules, it provides for two specific situations wherein data from clinical investigation may not be even.
Which page is that?
Your Lordship, I'm not aware of the page, Your Lordship, but the Medical Devices Rules, they provide for it, Your Lordship, under Rule 60. Your Lordship, under Rule 62 provides us again. Your Lordship, if in case that there's a life-threatening, Your Lordship, there is a threat to human life, or in the second case, if the device is a Class A medical device, the Central Drug Authority can grant approval without considering the clinical investigation data. Your Lordship, in this case, what the ICMR guidelines have to be taken up by is an ethics committee, which is a separate body that is constituted under Chapter 7 of the Medical Devices. Your Lordship, what the ICMR guidelines have to, even if so, have to be complied by is the ethics committee. Your Lordship, the approval of the Central Drug Authority can be granted even without taking that into consideration in these two cases. Your Lordship, since The parameters have been listed in the schedule of the Medical Devices Act. The parameters for classification as to what is a Class A, Class B, Class C, and Class D device. The only parameter that applies in this present case in regards to doctor precision is that it is a non-invasive device. The Lordship, non-invasive devices, other non-invasive devices, specifically that is provided under the schedule, are Class A medical devices. So in Class A medical devices, the Central Drug Authority can still grant approval. Your Lordship, to the submissions of the petitioner in that regard,
Rules provide for any AI tools also for diagnosis.
Your Lordship, the AI tool is not. Your Lordship, the rules do not provide.
Are concerned with AI.
Your Lordship, it does not provide for
It's not
that.
static.
Your Lordship, but software, Your Lordship, AI is still software.
Yes.
Yes, Your Lordship. So since it is software, Your Lordship, and that has been notified by the Ministry of Health and Family Welfare, that these will also come under the medical device rules, and based on that only this procedure has been taken up by the Central Drug Authority. Your Lordship, I'd like to rest my case.
You answer that question regarding court.
Your Lordship,
Suppose somebody is convicted under 302, 304B, 376, or any one part. She said that there are some rules, you must be name of the victim of a primary instrument, sexual also and all that. It is an accused law. He has a right of privacy.
Your Lordship, I'm not aware of that.
Whether he should have,
Your Lordship.
what is your opinion? We are not talking about law.
Yes.
Whether he should have, you have read all these judgments from me against from.
Yes, Your Lordship. Your Lordship, if we may repeat the point, Your Lordship.
Point is, person A is convicted for any offense. Right? He says, all right, I am convicted. How can you put my name on the any footer? So what anybody can go and search. See, this A is convicted. There are thousands of persons with the same name. No detail of parents, no detail address and all that is there. Only first name.
Sir, Your Lordship.
But what is that?
Your Lordship.
Number one. Number two, there is correlated. Now, if you go to any search engine, they only have the information about the cases which they are. Beyond that, there is another case where all the judgments are there as we go system. That is not accessible on the website. That is a separate system. If you carry on search, data from that will not be available. It is only available on that platform. So you say, today I am convicted. Maybe, or like you have uploaded. Tomorrow I am acquitted also. That order nobody uploaded. So in records on the website, I am the convicted person. But he has a right of privacy. Say, why you have uploaded my order? First case. He has said that yes, it is from the public commission. All right, fine. This is by my name.
In specific cases like even X versus Union of India, that was stated in 2023. A victim's name was not provided, Your Lordship.
That is one part.
Yes.
Victim of crime.
Only in the
one
case
part.
of 376 or workshop.
Also, crime against women, there are guidelines. Now, matrimonial cases also there are guidelines, right? You need to be masked. So there is a accused also. But why you have uploaded my name?
Your Lordship.
What right you have to upload on the
Yes, Your Lordship. Your Lordship, I believe what you're talking about is the right to be forgotten.
Yes.
Your Lordship, the right to be forgotten also has
Right to
to
privacy also, forgotten also.
Yes, Your Lordship. Your Lordship, the right to be forgotten also has to abide by certain reasonable restrictions. Your Lordship, since it's a matter of public record, even under the right to information
Public
Act,
record in the office,
yes,
no problem. Yes. Putting it in public domain on the website,
yes,
accessible to the entire world.
yes, Your Lordship. Your Lordship,
Take
I mean,
take all
very
that.
exact answer.
Yes.
Kind answer, Your Lordship.
Thank you. Thank you. Yes, yes.
Greetings in honorable board. The Lordship, I'll be addressing the second issue that deals with privacy and consent. The Lordship, I would like to humbly submit for the board that privacy is not an absolute right and all aspects of privacy cannot be protected at all points. Secondly, I would like to state that Medtech Futura have complied with section 43 capital A, read with section 72 clause 2 of Cyber Technology Act with reference to SPTI rules, and also that Medtech Futura is protected by contract law as they have entered into a valid agreement. As we all know, Your Lordship, Article 21 lays down that the right to privacy, and I would like to reiterate that the right which is being vested on Article 21 is subject to reasonable restrictions. In certain cases, it is impossible to protect the right that is being vested on Article 21 at all points. For this to be supported in Sharda versus Dalbar, the issue was addressing whether the investigation of checking of the unsoundness of wife was violative of privacy, where it was noted that Article 21, however it confers right to privacy, it was said that it must be read under the clause of personal liberty. And even if it is read under personal liberty, certain limitations are being vested upon, are being imposed in certain cases by legislature and by law, which tells that it is not an absolute right, and for the arguments in support of it for the right to privacy not being an absolute right, there is another case where X versus Hospital Y during the investigation of the breach of information while of the doctor who was dealing with the context of breaching of doctor-patient confidentiality, it was said that privacy was not an absolute right. With that being said, I would also like to quote case Kutuswamy versus Union of India 1, where the court turned to the EU regulation of 2016 and observed criminal offence as restriction to privacy as mentioned in paragraph 640. Apologies, Your Lordship, I do not have the judgment copy. However, it is mentioned in paragraph 640. Moving on, I would like to state that how the procedure established by law, as mentioned in Article 21, it says that procedure established by law, which is in this case will be the contract law. The clauses that are being mentioned in the agreement mentions the open usage of the information for the enhancement of the software. For this, I would like to bring in section 43A clause 2, capital A clause 2, read with section 72 clause 2 of Cyber Technology Act. There, the section deals with the reasonable security practices and procedures, where it mentions that reasonable security practices and procedures means security practices and procedures that are designed to protect such information as may be specified in an agreement between the parties or may be specified in the law for the time being enforced. In the absence of such agreement or any law, such reasonable security practices and procedures as may be prescribed by the central government. I would like to put forth that in the agreement clauses that are mentioned in the clauses that are mentioned in the agreement, there is an express. Yes, sir.
How do you make this proposition 15 and 16? How do you get out of it? Please go through your proposals. The Moot proposition.
Yes, sir.
What proposition do you have? Take this.
Yes, sir.
There are 15.
15 and 16, how do you get out of it?
Your Lordship, the leak of personal details.
Because of this leak, what they're claiming is, why they're claiming compensation. There were widespread disturbances. One of that
Your Lordship, the leak
against a community, which is a vulnerable community in this country. That is one. The second, because of this leakage, Dr. Precision, you see that people are well treated after whatever he did. He treated them well. There is no reason They have not released anything against them. That is one of the contention raised by your brother colleague. There is nothing against precision. Why should they lead anything against precision? Precision has treated them well. They got well treated by Dr. Precision. How do you get out of these two propositions?
Your Lordship, with regards to the paragraph number.
The way you answer goes to your marks.
Yes, sir.
It's not that what you answer. The question is how you answer.
Yes, sir. With regards to the leak of personal details, Metric Futura being an intermediary, however, even though it is mentioned in section 43A that compensation must be granted in certain circumstances, it is pertinent to note that whenever there the body corporate possessing, dealing, or handling any sensitive personal data is negligent in implementing and maintaining reasonable security practices. In this case, Merited Futura have not portrayed any amount of negligence from Merited Futura side and have taken necessary measures in order to protect the privacy and also to ensure due diligence. Due diligence with regards to the SPI Rules Rule 8, Your Lordship, if I may quote, it lays down the reasonable security practices and procedures. It says that a body corporate or a person on its behalf shall be considered to have complied with reasonable security practices and procedures. If they have implemented such practices and standards, if they have implemented such practices, standards, and have comprehensive documented information that are commensurate with the information, the body corporate or person on its behalf shall be required to demonstrate and may be extended. And with that being said, in Rule 8, Clause 2, it mentions the existence of ISO standards 27001. If I may produce the copy of 27001, ISO 27001. In this ISO, there has been no explicit mentioning of the standards that has to be followed by MedTech Futura. And if I continue with where in section 43 capital A subclass 2 reasonable security practices, it is in the first area it is mentioned that it must be specified in an agreement. From MedTech Futura side, we have expressly mentioned the usage, the type of data that we are acquiring, and the usage for and the reason why they're using the information. And that being said, and the second one being the law that is being law for the time being enforced, which is contract law, which is supported by procedure established by law in Article 21. In the absence of such agreement, if we had not mentioned expressly for the usage of such information, such personal information of the patients, then in such scenarios, reasonable security practices and procedures will prevail. Even in that case, reasonable security practices and procedures as laid down in SPDI, which is bringing in the concept of which is bringing in the ISO standards, has not mentioned any obligation that has to be met by MedTech Futura or any other body corporate, which proves the point that MedTech Futura are clean and they have clearly mentioned the agreement, have met the agreement clauses and have not put it any harmful intention to breach the privacy nor lead to a part that would leak the data of the patients. Your Lordship, if I may continue.
Yes, sir.
Your Lordship, and the ISO, with regards to the ISO standards, in the ISO 27001, there is no explicit mentioning of the usage or about the transfer of information from one jurisdiction to another, which proves the point that there has been no guidelines or no rule, no law as such that has been brought in to say that no, the information should not be transferred to another country, no, the information should not be transferred to another jurisdiction, which also clears up the point that there has been no restriction forced by the other sector. Your Lordship, there have been no guidelines or law that has been passed to, yes, Your Lordship. For the support of this argument, I would like to quote another case of University of Texas versus University of Texas MD Anderson Center Cancer Center versus United States Department of Health and Human Services, where the respondents argued the need for encryption and for the implementation of a mechanism to implement reasonable and appropriate methods for the safeguarding of privacy of the patients or the citizens of the country. For while this was taken in an appeal, United Court of Appeals for the Fifth Circuit stated that it cannot be at all points regulation it cannot be put forth that a mechanism at all points should be universally enforced, or how impervious to human error it could be, or the hacker malfeasance should be taken the responsibility for. So the regulation simply says for the existence of a mechanism for which Merited Future have brought in a mechanism to maintain due diligence. With regards to due diligence, self-regulation has been followed by Merited Future, where one second, where self-regulation has been taken care of by Merited Future, and reasonable practices and procedures are also complied by. And since both due diligence is also ensured and necessary to protect the data of the citizens and Mr. Bargains, and following the conditions that are enlisted in the rules and statutes put forth by me and my co-counsel, it is said that whatever the mechanisms or the necessary steps that have to be taken in order to protect the data have been taken from Merited Future side. And in clause B of the agreement, it is also put forth that in the event of any information, in the event of information or computer resources, the liability will be exempted. Only and Merited Future have also taken safety measures. Only in certain events they are exempting themselves from the liability, which says that reasonable care and supervision has been taken care by Merited Future. That being said, Your Lordship, I would like to say that even in this case, hacking has been done by an anonymous account who had a profile in Chirp. No way is the anonymous account related to Merited Future. Merited Future. Alone Hurst, being a majority shareholder in Merited Future and being the CEO of Chirp, a random anonymous user who got the control or who got the immunity to post share videos because of the data leak that has been done by an anonymous user. Merited Future as an intermediary cannot be held responsible. That being said, Your Lordship, I would like to say that in this agreement, in the agreement clauses that I explained a few seconds back, the exemption clause is fair and reasonable as it merely exempts the liability from Merited Future. And it is also said that there is no fault on its part and has no wrongful intention to defraud Mr. Baggins or the suspected patients, as the core aim of Merited Future is to save the information, and the reason why the information are being saved is for the enhancement of the efficacy of the software. Number one, and number one would be the diagnosing of the diseases, and number two would be the enhancement of the software. Both being said, there is no wrongful intention that is being quoted by Merited Future, which would lead for the data breach or data leak. And even if there was an active intention, and I'd also like to say that there is no active intention of deceiving another involved. And that being said, Your Lordship, I would like to say that unreasonable protection cannot be granted at all circumstances, as reasonable measures up to the extent of which Merited Future can exercise has been done from Merited Future side, and the due diligence part has also been taken care as they have brought in encryption mechanisms and endpoint security as mentioned here. And but even in such circumstances, hackers do find some way to access systems even if they are protected at the highest degree. That being said, Your Lordship, I would like to conclude my argument saying that that Medtech Futura have complied with section 43 capital A read with section 72 clause 2 of Cyber CTA and with relevance to SPDI rules. And this right to privacy being subject to reasonable restrictions, it is said that it is not an absolute right and all aspects cannot be protected at all points. Lordship, if I can proceed with the prayer. Wherefore, in the lights of facts stated, issues raised, arguments advanced, and authorities cited, it is most humbly prayed and implored for the Honorable High Court of Elysium may be pleased to hold that prima facie case is not made out against first and second respondent and therefore must be quashed. The public interest litigation PIL filed by Forum for Netizens Rights not be allowed. Also pass any other order that this Honorable Court deems fit and proper in the interest of justice, equity, and good conscience. For this act of kindness, the respondent shall be duty bound forever to credit. Thank you.
Only thing is not cited, referred. So they have not produced the judgment. You have made reference.
Yes, sir.
The word should be judgment referred.
Correct.
The council function to rebut.
I think it's thank you.
In the light of justice, I will just take 2 minutes to rebut the learned counsel petition with that.
If you want, we will not.
Yes, welcome.
Welcome.
We are not deciding the case, so not.
We are deciding your skills. We are not deciding whether the FIR should be lodged, whether it should not be lodged, right? Whether you should get first prize or they should get first prize is the only question.
Not whether you
Your spirit is important.
In the present case, the agreement which is signed between the respondent company and the patient fails to honor the principle of information privacy and therefore it is void. If we look at the privacy policy of platforms like ROT Setu, they explicitly mention the kind of data that is to be collected, which Medtech Futura has not done in the present case. Further,
They were not information.
Your Worship, the permission so granted to this tool by the Central Drug Authority has also been questioned by my co-counsel. Your Worship, I would like to respectfully submit that the council is in no way challenging the powers of Central Drug Authority to grant such approvals. The authority is very much under the statute to grant such approvals. However, we have a problem with the discretion so exercised because they have not given due regard to the privacy implications associated with the said rule. Further, Your Lordship, the ICMR guidelines is referred to by my co-counsel. The guidelines clearly mention that the guidelines have to be followed by the Ethics Committee. Now, the Drugs and Cosmetics Act mentions that the Central Drug Authority has a Ethics Committee which has to follow these guidelines. Therefore, since there was no AI regulatory framework in the Republic of Elysium, it was a duty and obligation of Central Drug Authority to pay heed to these guidelines. Your Worship, to conclude, I would also like to state that since CHIRP is a significant social media intermediary, then by the virtue of the judgment of Facebook versus Delhi Legislative Assembly, it was the responsibility of CHIRP to exercise due diligence under the intermediary guidelines. Further, the jurisprudence of actual knowledge as cited in Shreya Singhal versus Union of India 2015 has undergone a significant change because the judgment is a decade old and internet is an ever-changing space. Therefore, when the knowledge was received by the intermediary with regards to the incidents of stereotyping and violence against the intermediary, against the patients as well as the Nirvana type community members, it was the obligation to remove the point.
Lordship, if you may address the. Your Lordship, in the first place, Article 13, Clause 2 does not provide for guidelines. Guidelines are not law, Your Lordship.
Only thing which court you were referring? High Court, Supreme Court, or to
High Court, Your Lordship.
High Court.
Yes.
Then what is the code for High Court? You should have a gown and the belt. And the
At
second
least a
thing,
tie.
even if you are in trial court, you must have a tie.
Your Lordship, I didn't have a tie. My
Then it's your
mistake on
college
part.
anywhere you go, the minimum requirement is the tie.
Yes, sir. Pardon me, Your Lordship. That is correct.
And in my time, we were not provided anything by college. Your time, your college provides you everything. The memorials, people to prepare your memorials.
No, but then
Yes,
I
sir.
tell you, the 1 year we have studied all our life. That's the difference.
Not like that which us.
Not that was the first.
Not 1 year, my lord. 1 semester.
I think law we will not pay more than 1,000 per session.
No, my 1 year lecture was by full fees.
My mother used to say the same thing. Your Lordship, in regards to the ethics committee, Your Lordship, the guidelines are not even binding on the ethics committee. My submission was that if any, the ICMR guidelines would be taken notice of the ethics committee only. But even besides that, as per the procedure under law, under the medical devices rules, the Central Drug Authority still has the power to not even take consideration of that. So going as per law, the Central Drug Authority cannot be liable for anything. Your Lordship, finally, in regards to the
Here's the issue of clash of interest.
Your Lordship, in regards to the Shreya single case, Your Lordship, under Rule 3, Sub-Rule 1, Clause D of the Cyber Technology Rules 2021, it will be provided that. Yes,
Your rebuttal is repeating, nothing else.
Your Lordship,
Tell us something new.
Your Lordship,
Not the rebuttal.
They come feel you have done well.
yes, Your Lordship. Answering to the rebuttal. Yes, Your Lordship.
This will go negative against
Your Lordship, it specifically states that actual knowledge should be in the form of court order or by court of, by an order by a court of competent jurisdiction or on being notified by the appropriate government or its agency. Your Lordship, that means the principles of Shreya Singhal still stand, Your Lordship. Your Lordship, I kind regards, Your Lordship.
Thank you.
So you are from where?
In that case, I will. No, no, ये पच्चीस परसेंट.
They are not supposed to.
No, they are not
share
supposed
So now it's all right.
okay.
None of it is from Chennai. But anyway, you people are from Bombay. Oh, capital. From National University.
But the inaugural માં આવેલો વેલી વિક્ટરી માં કેસ.
ये आप लोग
No, no. But
I request everyone to please be seated and let the honorable bench pass and after we can please.
okay. Good question. आप तो है ना.
All right.
Meet you at the venue.
All the best.
भैया
Mr. Justice Rajesh Bindal. Respected Honorable Mr. Justice Rajesh Bindal, Honorable Dr. Justice Kaushal J. Thakur, Dr. J.M. Vyas, Honorable Mr. Justice A.G. Uresi, Honorable Mr. Justice R.P. Dodaria, Professor Dr. C.D. Jadeja of the dais, Professor Dr. S.S. Jadhari, Professor Dr. Purvi Pokhariya, Deans, faculties, staff, students, and dear participants. I, Radul Singh, heartily welcomes you all to the valedictory ceremony of the second NFSU National Technological Moot Competition organized by the School of Law, Forensic Justice and Policy Studies, National Forensic Sciences University, in association with the Indian Cybercrime Coordination Center, I4C, and Gujarat State Human Rights Commission, with Eastern Co Company as the knowledge partner and Supreme Court Cases Online as the media partner. It gives me immense pleasure to stand before you all today on this auspicious occasion where we have gathered to celebrate the culmination of months of hard work, dedication, and legal prowess displayed by our participants. We witnessed passionate arguments, meticulous research with an expansive embodiment of legal acumen, and it has only been possible owing to the humble time, expertise, and wisdom shared by our distinguished dignitaries present in this forum. To express our heartfelt gratitude and appreciation to the dignitaries, we wish to felicitate the distinguished dignitaries here. Firstly, for this, I will now request Dr. J.M. Vyas, Vice Chancellor of the National Forensic Sciences University, to extend our gratitude to Honorable Mr. Justice Rajesh Bindal, Judge, Supreme Court of India, with a token of our appreciation. I again request our Vice Chancellor, sir, to extend our gratitude to Honorable Dr. Kaushal J. Thakur, sir, the chairperson and also a supporting partner with the second NFSU National Technological Moot Competition. I may now request, sir, to again extend a heartfelt gratitude to Honorable Mr. Justice R.P. Dodaria, sir, former Judge, High Court of Gujarat. Please, sir. Thank you, sir. I would again request you to please extend our gratitude to Honorable Mr. Justice A.G. Urezi, sir, former Judge, High Court of Gujarat. Yes. May I now request, please take your seat, sir. I may now request Professor Dr. Purvi Pokharial, ma'am, Campus Director, NFSU, and Dean School of Law, to extend a gratitude to our most beloved Dr. J.M. Vyas, sir, Vice Chancellor, National Forensic Sciences University. Now, I will request Dr. Navtika Singh Nautiyal, Assistant Professor at the School of Law, to extend a gratitude to Professor Dr. S. Junade, Campus Director, NFSU Gandhinagar. Please, ma'am. I will now request Dr. Deepak Mashru, Assistant Professor at the School of Law, to extend our most love and appreciation to Professor Dr. Purvi Pokharial, ma'am. Please, sir. With this humble beginning, I will now take the proceedings ahead and request Professor Dr. S. Junade, our most supportive campus director, sir, National Forensic Sciences University at Gandhinagar campus, to please address the gathering with a welcome address. Thank you, sir.
Respected Honorable Justice Rajesh Bindal, sir, Judge, Supreme Court of India, our Honorable Vice Chancellor, Padma Shri Dr. J. Vyas, sir, Honorable Vice Chancellor of National Forensic Sciences University, our distinguished professor and guide, Dr. Kaushal Thakkar, sir, Chairperson, Gujarat State Human Rights Commission, Justice R.P. Dholuria, sir, former Justice of Gujarat High Court, Professor and Justice A.G. Urezi, sir, former Judge of Gujarat High Court, and our dynamic Dean of School of Law, Forensic Justice and Policy Studies, Dr. Purvi Pokharial, madam. On behalf of the entire NFSU family, I welcome the dignitaries on the dais. We have accepted our invitation and to make this very function very much successful. I also thank all the delegates, our faculty members, and students for making this 2 days special National Technological Moot Court competition very much successful. So we will listen to honorable judges and dignitaries on the dais. So once again, on behalf of entire NFSU family, I welcome all the esteemed judges and esteemed dignitaries sitting on the dais and off the dais. Thank you very much.
Thank you so much, sir. Now, it is time for us to witness the journey of the 3 days of the second NFSU National Technological Moot Court competition of the dedication, talent, and passion of all the participants and the stakeholders. For this, I will now call upon Professor Dr. Purvi Pokharial, Dean at the School of Law, to present the report. Please, ma'am.
Good evening, Honorable Mr. Justice Rajesh Bindal, Judge High Court of Judge Supreme Court of India, Honorable Dr. Justice Kaushal Thakkar, Honorable Justice R.P. Dholakia, Honorable Justice C.G. Urezi, our beloved Vice Chancellor, Dr. J.M. Vyas, our Campus Director, Dr. S. Jonathan, all the distinguished participants from different law schools in India, my faculty colleagues, ladies and gentlemen. This 3-day event, I'm here to give the report of 3-day event. As we all know, we all started from 23rd March evening. We had an inauguration and we had Additional Advocate General and Justice Kaushal Thakur for this inaugural ceremony. And then this is a very different kind of mooting format that we try to embrace in terms of two preliminary rounds to ensure that we have a fair game. In terms of the fair opportunity is something which is so important in any of these processes. So in that context, we have a double preliminary round, double quarterfinal round, and thereafter we have today we had morning sessions. We have semi-final round, and total 4 teams are there in semi-final, and then just before an hour ago, we have witnessed the final round. As all of you know that we have 38 teams total in this competition from all these prominent national law schools and the other esteemed law schools from the country. These this particular moot court competition was addressing the name of the competition is Technological Moot Court Competition because it addresses the technology integrating legal issues, because as we all have understood by now, the technology is the major drivers of change in today's context. And in that regard, as we have seen that the future litigation and future legal services industry is going to transform in an amazing way due to the advent of new technology. This technology is really transforming our lives, but at the same point in time is also giving a lot of challenges to the legal system. So how do we identify those legal issues and how do we harness our technology in such a way so that it becomes beneficial to all people, having an inclusive approach and a rule of law. So in that context, we have had this competition. This is the second season of our competition in this year, and we are indeed grateful to Honorable Mr. Justice Rajesh Bindalji, the Judge Supreme Court of India, who have kindly consented to be with us to preside over the final round and even to preside over the valedictory session. So on behalf of the entire NFSU family, once again wholeheartedly welcome Honorable Justice Bindalji. And I'm sure that the competition has been a seamless and smooth, completed within time frame. All of the participants must have experienced the vibrant ecosystem of NFSU visiting different centers of excellence. And I'm sure your this journey would be a memorable one. We would like to take your feedback also at the end of the sessions, and we look forward to host you again in the next season. Thank you.
Thank you, ma'am. I now take this opportunity to welcome and introduce Honorable Dr. Justice Kaushal J. Thakur, Chairperson of the Gujarat State Human Rights Commission, which serves excellence rooted in justice and scholarship. Please, sir, I may request.
Good evening. कैसा तुलसीदास जैसी किसको नमन करूं, यहाँ है बिंदल साहब है, पहले किसके पैर छू, आप सबको भी ऐसा ही होगा भविष्य में. You'll have your mentors somewhere, you'll have your guides somewhere. My Lord Justice Bindal, Judge Supreme Court of India, Padma Shri Dr. J.M. Vyas, one of us, जिसका मैं सुशिष्य हूं ऐसा तो नहीं कहूंगा, प्रशिष्य हूं. वो कृष्ण है इतना मैं जरूर कह सकता हूं. तो मैं अर्जुन हूं तो आपकी बताएगा. My esteemed senior colleagues, Urezi and Dularia, Dr. Judare, Dr. Purvi Pokharia, Dr. Vishwa, Dr. Singh, all my colleagues, faculty. Being a partner, I'm supposed to feel something. It was wonderful being with the two stalwarts with whom I could share a bench today. And let me tell you, the Moot Court students, the Mooters rather, were really very good. A round of applause for all of them. And as I told you, it does not matter whether you win or you lose. See, if you have seen Three Idiots, Madhavan was a dropout. He didn't give his finals. Despite that, he was a successful writer. Rastogi, if you have seen the end of the movie, the young boy tells, "आपके सभी किताबें वो पढ़ता है." He's a blogger, acclaimed. So it doesn't make a difference whether you are a first ranker or second. Normally, first rankers go in oblivion. Ranchod was never there. Nobody knew him. He was operating from somewhere in Leh. These are the lessons of life. As I've been telling, moot courts are here to teach you something. You take home your lessons. All those who could not make it to the final, don't get disheartened. These are not your finals. Your finals will be when you get your degrees, when you move to the courts, when you have difficult questions, and not questions only to be asked to be answered for your marks. I'll not take much time, and I would anxiously hear both these stalwarts sitting here in the audience. And there is a request which I'm putting it to my campus director. Saab yahan ek ghadi lagwa dijiye. Thank you.
Thank you so much, sir, for your words of encouragement.
This is for you. For 26 years, let me tell you, I have not taken a bouquet home, except on my birthdays.
So please let us know when your birthday is. We shall deliver it myself. I shall let it down. Thank you so much, sir. Now, I take this esteemed opportunity to introduce and welcome our most honorable Vice Chancellor, Dr. J.M. Vyas, sir, who is a distinguished figure in the realm of forensic sciences and academia. As the founding Vice Chancellor of the National Forensic Sciences University, Sir has been appointed as a member of India's prestigious Council of Scientific and Industrial Research under the leadership of our Honorable Prime Minister, Shri Narendra Modi ji. Sir's remarkable contributions have earned him the esteemed Padma Shri Award, which is a testament to his exemplary service to the society in the fields of science and engineering. We are so glad to have Sir as the shining light of all our endeavors. I will now request Sir to please take the dais and address the gathering. Please, Sir.
The chairperson of today's function, Honorable Rajesh Bindal Saab, Honorable Justice Kaushal Thakur Saab, Honorable Justice Gorezi Saab, Honorable Justice Toloria Saab, Dr. Junale, Dr. Purvi Pokhariya, faculty members, and dear participants. Indeed, a pleasure of hosting this moot court. In fact, I was not to speak, I was not in the list, but she announced that I'm here. I was just thinking, gaining a knowledge and then transforming the knowledge and making it more beautiful is important in the life. And knowledge can be gained by many ways. One of the ways our scriptures were mentioned, you can do it by reading. You can do it by listening. And then also you can do it through vichara, thinking. So reading,
listening and thinking. Three processes. Now, to make this knowledge effective, these three aspects are that you can read, but that reading may not be because mind is not available. So my availability of mind is very much required. You may listen to my talk, for example. Your mind is checking, so I'm going somewhere in US, what my son is doing, what my brother may be doing. So though the listening is there, but it doesn't take place, listening is not effective because the mind is not there. Ears are there, but still, however, the listening doesn't take place. Eyes are there. You are watching the book. The reading doesn't take place because there is no mind. Vichara is there, but there is no mind behind that. So you are not able to do anything out of the thoughts which come in your mind. So every exercise you do, there has to be a presence of mind. Then only it becomes effective. So when the mind is there, the reading, the listening, the thinking becomes effective. Now that also is not important. See, you read, you know, knowledge is knowing, you know. Now, simple knowing is not also effective. Say, I gave example in my speech. Sugar is sweet. There is a knowledge. Now, when you also need a special knowledge, we say Vignan, special knowledge. Gnan and Vignan. Vignan is special knowledge. Now, you take sugar, you add sugar in milk, and now you are consuming. So now you have research knowledge, special knowledge about the sweetness of the sugar. Otherwise, what we call in psychology is experiential knowledge. Otherwise, that knowledge was in the level of conceptual knowledge. Now this has become an experiential knowledge that you know the taste of sugar because you have taken it yourself. So these are different modes. Now the third important thing is that knowledge what you gain, special knowledge what you gain, has to be made, transformed, converted into a meaningful knowledge. And that we call a skillful knowledge. And that skillful knowledge is very important, though you are a very knowledgeable person, but you are not able to implement that knowledge in a proper mode, then it doesn't work. And therefore, this Moot course are conducted, where your knowledge, you are able to place it before someone. How you argue, how you grasp the thing, how you understand the mind of the judges, how do you respond to the queries and questions of judges, how quickly, how best, what kind of acts you are referring, you are quoting, whether they are relevant, they are not relevant, presence of mind. And that's learning. That's the best method, I would say, of learning this. You practice it. So that knowledge is to be practiced to make it meaningful. So what we did today is practicing that knowledge. This is what we have been doing for the last 2 days. So this is how it is very important. Whatever you try to learn, and then ultimately knowledge is power. I say to the student, knowledge is power. You will be recognized by your knowledge. Whatever you may be. If you don't have knowledge, nobody will recognize you. Knowledge is power. And our sutra is there. Knowledge, wisdom, fulfillment. That is what NFSU says. So knowledge gives you wisdom. It makes you a wise person. What is wise? Matured person. Knowledge gives you maturity. And ultimately, what do you want in the life? Fulfillment. So that fulfillment comes from maturity. That now you are able to assess every situation which you come across in your life. Proper assessment of the thing. Each and everything which you come across, try to assess. and that is maturity. We also call many times emotional maturity. It's not a simple maturity. Maturity doesn't come with the age. Person may be 75 years old, not matured at all, emotionally. Emotional maturity is mind is now available to assess every situation. I used to give an example, time is short, but then we used to play pebbles. And then winning pebbles, when I was 4 or 5 years old, winning pebbles for me was winning the whole world. And losing the pebbles was losing the whole world. So I was losing, I will go crying, entering the home. No, mother, I don't want anything. I don't want to take anything. I don't want to eat now. Then mother used to ask, Beta, what happened? Then mother, I lost 5 pebbles today. And then she will try to convince me that losing this now, but I was not able to convince myself. No, I lost the world. And next day I won 5 pebbles. I entered the house in a different colorful mood. Mom, I want more rotis today. Why? I want pebbles. So winning pebbles and losing pebbles was a victory or loss for me in my life. And the same person became father or mother. Now this mother or father playing pebbles with the children. Now this for father and mother, winning and losing pebbles it doesn't make any difference because now he's mature. He's matured to understand the importance of pebble in the life. Likewise, we should develop that maturity where we can understand the importance of everything in our life, including the wife, the husband, the children, how far they are important. That is maturity. Thank you.
Thank you so much, sir. Your positive words and sheer brilliance has, I'm sure, must have fueled the audience with pristine wisdom. Thank you, sir. I now take this humble opportunity to welcome Honorable Mr. Justice Rajesh Vindal, Judge, Supreme Court of India. Lordship comes from the military city. Sir, allow me to introduce you, please, sir. Please. Lordship comes from the military. Please, Lordship, take the seat. Lordship comes from the military city of Ambala, where after laying foundations in legal education,
dignitaries, members of the church, members of the previous rules, ladies and gentlemen. That's also a case of learning from me when I came here in this simple competition. And wherever I went, I think I have been to 4 courts, saying Supreme Court also, the performance of the students is far excellence and better than many advocates who are practicing, even in Supreme Court, I can say. So, but one thing is there, I don't know how much of you will join litigation. Many of you go in the corporate world. But I think you should join litigation also, because we need growth of law in the court also, because the law has to grow with the society. So unless you people also come in profession and make the law grow, I think that will be a very good idea. Now this is Professor Vyas, Dr. Vyas has told you. Now this is the quality of a teacher. How he can in a simple word convey everything to you. With simple example. And this you will never forget in your life. And I can share my experience. I was in 5th class, 1970, I'm telling you. And I still remember we had a Hindi teacher at that time. He taught us alphabet of Hindi. And I still remember that. The way of teaching was, he said, you remember first letter of each line, that's all. Just see. This is how the teachers make you understand. And many of you may not be remembering that Hindi alphabet. We have not used it, we are not using it, but it just imprinted in the mind. This is the simple way he has explained you many things. How you learn? Learn by doing. Because he has explained that your mind is not there, you will not learn. If the monologue is there, the teacher is giving a lecture. And now the problem is different. The teacher comes, he gives a lecture to you, you know what lecture is there. Now Google Baba is there, you have more information maybe than the teacher. So you say what he is or she is speaking. I already know it. Your mind is closed. You will not be receptive to anything. So this is the major problem which is being faced now. But still, the idea of teaching is now changed totally altogether. In our time, it used to be the lecture only, nothing more than that. No moot court. I did my law in 1985. Nothing